On the 3rd of October 2022, the cabinet lifted the ban on GMOs that had been put in November 2012, restricting the cultivation and importation of foods and animal feeds that are produced from genetically modified seeds and other organisms. Aggrieved by the cabinet directive, Paul Mwangi and the Kenya Peasants League challenged the directive on grounds that it was a blanket lift of restrictions without the establishment of measures to preserve indigenous resources, threatening sovereignty of the people and, in particular, food security. The state, through the Attorney General, filed an application to the courts requesting that the directive on the lift of the ban is stayed, pending hearing and determination of the appeal by Mwangi and Peasants. The state argued the adoption of biotechnology involving the use of GMO will significantly contribute to addressing the challenges facing the country in terms of food security, as it will lower the cost of raw material for the animal feeds industry. A 3-judge bench constituted to handle the application said they sought to establish whether the case is arguable, if an order of stay was reversible, and if the application of the Attorney General was indeed driven by public interest. Justice Mohammed Warsame, Ali Aroni and John Mativo say the application lacks merit and the decision by the state was reached without public participation, and I quote, "Decision arrived at was not subjected to public participation. Why the report which preceded the making of such a declaration was not made public to allow stakeholder engagement." End of quote. This means that the order barring government from importing or distributing genetically modified crops and food stands until a case filed at the High Court by the Kenyan Peasants League, a social movement, is heard and decided. David Kagina, K24, Nairobi.